It's the judgment of this court that the defendant should be sentenced to the custody of the Idaho Department of Corrections for a total unified sentence of 15 years. That will consist of a fixed minimum term of 3 years and an indeterminate term of 12 years. The court is going to recommend that during any time the defendant is in custody, that he be given access to both sex offender treatment and substance abuse treatment. The defendant will be given credit for all of his time served. I know he's been in custody since January 22nd, plus he did approximately 20 days last fall, so we'll figure out the exact number and give him credit for every single day he's already served. The court is going to impose a fine that's not a reflection of how serious this crime is, but it's more of a reflection on your ability to pay, and so I'm going to impose a $1,000 fine. Frankly, I could impose a $50,000 fine here, but I know you have no capacity to pay that. The standard court cost will be $165.50. Because this is a sex offense, the victim's relief fund payment will be $375. I've considered whether or not I should impose a civil penalty in this case. I do find that some of this crime may have been facilitated, the evidence before me, by the victim and for potentially members of her family as well. And so because of that, I don't think a civil penalty would be just, but I am going to order restitution. And the defendant will have to pay for the consequences of his actions on the victim and her family. The state of Idaho will have 30 days to submit a request for restitution to the court. If it appears reasonable, I will sign that order. Mr. Hanson, I'll provide you with a copy of my order, and if you object to it for any reason, then we'll set the matter for an evidentiary hearing to determine whether or not the full amount of restitution should be ordered or not. I am going to order, pursuant to Idaho Code 188307, that the defendant register as a sex offender, potentially for the rest of his life. There is a procedure after 10 years where you can seek relief, but again, that'll be something you'll have to deal with. Typically, these kind of restrictions last for life, and if you can persuade a judge in the future to shorten that after 10 years, then that'll be up to you. Now, in determining whether I should suspend that sentence or impose that, I've considered all of the factors, both in mitigation and aggravation, that I've just gone over in detail. At this time, I make the following findings pursuant to Idaho Code 1925-21. I do find that the defendant is, pursuant to 1925-21-1B, is in need of correctional treatment. That can most effectively be provided by being committed to an institution. If he's not committed to his treatment, or doesn't believe he needs treatment, or doesn't believe he needed a crime, the worst thing we could do is put him on probation. But we need to keep him in custody until he can receive that treatment. I believe under Section C that a lesser sentence will appreciate the serious nature of this crime. And I also believe that imprisonment will provide an appropriate punishment and deterrent to the defendant and an appropriate deterrent to other persons in the community under Section E.